Yes, I think Lord, it's coming. It'll be here. Rainy day, little delay. Nothing else. It'll be here. It'll be here.
Affidavit
Should I switch over to appellate side matter? It will not take more than 10 minutes. Let me
Very good.
do that. Dakun.
Very good. Not the affidavit is here. It's here.
Well, we should have been given a copy of an affidavit 1 day in advance, or at least 6 hours in advance.
I'll find out. Not this rainy day. In fact, I was so hopeful in the morning when it was pouring cats and dogs that today is going to be a rainy day holiday.
Well, let us have a look at the affidavit. Can we come back tomorrow?
Tomorrow.
Lord, it's been affirmed this morning.
No,
That's why I couldn't have given that. Kichu nahi hai thing. But
But
this was supposed to be a formal affidavit, nothing else, my lord.
I still have to run it by the clients and take instruction. Well, I can come back tomorrow.
Lord, I was only supposed to give the calculation of the amount which was already there. There's nothing in the affidavit, Lord. Lord, let us finish it off. Lord, your lordship had indicated your lordship will want to finish it today.
Should we not allow him at least to have a glimpse of it?
Well,
Lord,
I'm not
giving
only
him-
that,
Lord,
but
it will take
formally,
him 5 seconds.
no, I know that, but formally I may have to run it by the clients once. Well, that is the
Lord,
difficulty.
it's an amount.
It
Let
is-
him not
there
admit
is-
the amount because
there
my,
is
Lord,
a-
my argument is not dependent
There
on
is
his
a
amount.
monitoring committee which instructs me. They look at everything.
Well, let him come and meet. Lord, if he has a problem, he can come back and do
Then
it.
we can we do one thing?
I can finish
Well,
mine.
Say, today let the learned counsel representing the banks, let them finish.
Very well, very well,
Then if Mr. Bachchat wants to respond,
very well,
and
Yes.
tomorrow you come back.
very well,
Yes.
very well. I'll do that.
In the meantime, Dakun. No, Kolbuto, I'm just passing it over. I'm only passing it over. In the meantime, let me finish up this judgment part.
My lord.
Actually, copy that, sir.
এখানে কি কিছু আদিত্য বাবু আমাদের কি লিস্টে কোনো টাইম মেনশন করে দেওয়া আছে অ্যাপলেট সাইড
my lord, there being any attachment. The attachment is only to the extent that he will not be allowed to withdraw.
Then what does the paragraph 1 of the order you were referring to
Yes.
convey actually?
It was the submission made by the award debtor. My lord, the submission may be accepted in the manner it has been made, or my lord, the order, my lord, may my lord direct otherwise. My lord, the submission is this. The order is this. My lord, it is not in the. I have shown it from the statement of accounts that it is not that the award debtor has brought in money. I have closed my WCL account. I have reorganized the two credit facilities and made adjustments in the two accounts. Therefore, my lord, it is nobody's case and it cannot be anybody's case, my lord, that the award debtor had brought in the money. No, certainly not. Both the accounts, my lord, were showing debit entries. Even today, they are showing debit entries. Now, my lord, I come to the most basic question, which fell from your lordship on the last occasion also, as to whether a cash credit account or an account of this nature can at all be attached. My lord, this submission was also made before the Honorable Court, my lord, and which is why, my lord, affidavits were directed. We filed an affidavit, to which they filed an affidavit in opposition, and we used a reply. We used a reply there too. Now, my lord, first of all, my lord, we take the my lord, so far as my lord funded interest term loan is concerned, my lord, there is an entry. If your lordship takes, my lord, the bank's affidavit of November 2022, 4th November 20, my lord, the thin one.
দেখুন কোথায় আছে? ফেব্রুয়ারি আপনার ওখানে আসলে
Lord, Indian Bank, 2nd, 4th November 2020.
let him find it out. It's not waiting. যিনি affidavit বলেছেন নভেম্বর।
Yes. My lord, your lordship will kindly take, my lord. These entries were shown to your lordship.
Statement of account?
Yes, my lord, statement of account. Kindly take, my lord, page 9.
Yes.
My lord, kindly take, my lord, the third entry from bottom, 4/2/2021.
Yes.
Your lordship has seen, my lord, FITL EMI. FITL.
Yes.
Lord, this has been debited, my lord. That means this amount has been, my lord, withdrawn. This is what the submission was. Debiting is withdrawal. Lord, what is this FITL? My lord, if your lordship sees my affidavit, kindly take, my lord, paragraph 4, page 4 of the affidavit, paragraph 4. Since the account was not being properly maintained and the same showed signs of slipping into the zone of non-performing assets, as per the banking norms and practices, the bank carved out a portion of the unrealized interest. My lord, interest is accruing. My lord, a loan, my lord, is an asset to the bank, my lord, because it earns interest. My lord, so long, my lord, it keeps on earning interest, that is, my lord, interest accruing is paid and realized, my lord, it is a performing asset, an asset which performs. The moment, my lord, incoming interest, my lord, stops being paid or is stopped being paid, my lord, we do not get interest on the amount, my lord, lent. Then in that case, my lord, it becomes a non-performing asset. The asset does not perform any longer. Now, my lord, it is in this context, slipping into the zone of non-performing assets, NPA, as per the banking norms and practices, the bank carved out a portion of the unrealized interest accrued in the aforesaid cash credit account and converted the same into funded interest term loan, FITL. As if, my lord, it is another credit facility, because so that the debit entries do not swell and the account becomes NPA on that date itself. My lord, we have to try, my lord, till such time it is possible, my lord, to avoid NPAs. Because our books, my lord, get bad with longer NPAs, larger NPAs. We cannot, my lord, we cannot be expected to sit on a stockpile of NPAs. That is why, my lord, we carved out a portion FITL so that the same could be repaid in installments. Borrower gets installments to repay it. My lord, this
Cosmetic surgery.
yes, I'm grateful to your lordship. Therefore, my lord, the bank has also debited the account for the purpose of transferring funds for servicing interest in the WCL account. My lord, this is that. My lord, this was done in terms of, my lord, the RBI circular.
That you have handed out, right?
Yes, I handed up to your lordship. My lord, during the COVID times, my lord, this was made mandatory. Kindly see, my lord. Paragraph 3, second page.
Yes.
In respect of working capital facilities sanctioned in the form of cash credit or overdraft, Lord, this was a cash credit facility, lending institutions are permitted to allow a deferment of another 3 months from June 1, 2020 to August 31, 2020 on recovery of interest applied in respect of all such credit facilities. Lending institutions are permitted at their discretion to convert the accumulated interest for the deferment period up to August 31, 2020 into a funded interest term loan, FITL, which shall be repayable not later than March 31, 2021. Lord, this funded interest term loan, Lord, is something which is not alien to banking concept. Lord, it is my money, my interest, which I could have earned, I could have kept it there, and ultimately it comes back to that account only, because it was open for a particular time. Within that time, it was not paid. So entirety of it, my lord, again, it is credited. That account is credited, my lord. This account is debited by that account. But that does not mean that I have allowed somebody to withdraw. Who is that somebody? My lord, it shows into which account it is going. FITL, WCL, my lord. These are not names of persons. These are names of accounts which the banks have created for the purpose, my lord, of my lord, making adjustments so that the account does not slip into the zone of NPA. Now, my lord, having said this, my lord, my first submission would be that this account could not have been attached at all, because this is not the property of the judgment debtor or the award debtor. My lord, a loan account, cash credit account, my lord, is in the nature of a loan account. In a loan account, I am entitled to money from the judgment debtor. The judgment debtor is not entitled to money from me. I have given loan. It is showing debit balance. I am entitled to money. It is my property. That could not have been attached. I could have.
But you have accepted that.
No. My lord, the second order does away with the attachment. I am allowed to make debit entries. And in any case, my lord, the acceptance, even if I go that far, my lord, just to answer your lordship's query, my lord, that there is an acceptance. My lord, it was at the interim stage. Your lordship is hearing it finally today. The attachment was not made and money was not taken from me and directed to be paid on that day itself. Your lordship is hearing my objection today. Your lordship, my lord, is entitled to pass an order on my objection. I have objected to it. Now, my lord, kindly take this judgment, my lord. This is 2010, volume 10 SCC, page 1.
Yes.
Lord, this is 2010, volume 10 SCC, page 1.
Yes.
Kindly take note, paragraph 47.
Yes.
At this stage, we wish to once again emphasize that debts are assets of the assigner bank. My lord, just to give a background, my lord, this was a case where, my lord, the bank had assigned its debt to an asset reconstruction company, my lord, under the Securitization Act. My lord, under the Securitization Act, a bank is entitled to assign its debt, transfer its debt to another person. My lord, the borrower challenged the assignment. My lord, to this, the Honorable Supreme Court says, what is your right to challenge, sir? It is not your property. It is the person's property. The person is transferring it to some other property, some other person. No, but in this context, my lord, at this stage, we wish to once again emphasize that debts are assets of the assigner bank. The High Court has erred in not appreciating that the assigner bank is only transferring its right under a contract and its own asset, namely the debt. As also the mortgage is right, my lord, we are not concerned with that. Therefore, my lord, this debt is my property. It is not the property either of the judgment debtor or, my lord, of the award holder. Award holder's property, if it could have been, my lord, then in that case, no order of attachment was required. Only if it was the property of the judgment debtor in the hand of a third person, then only, my lord, a question of attachment of that property arises. My property in my name, in my custody, will be attached for the benefit of somebody else, my lord. I fail to understand this logic, this law. Now, my lord, today, today the account has become NPE. It is a non-performing asset. Lord, once it becomes a non-performing asset, then also, my lord, it still remains the asset of the bank only. This is, my lord, 2008, volume 1 SCC, page 125, Transcore versus Union of India. Sir, 2008, volume 1 SCC, 125.
Yes.
Lord, kindly take, my lord, paragraph 13, 1-3.
Yes.
Non-performing assets are a cost to the economy. When the act was enacted in 2002, the NPA stood at 1.10 lakh crore. This was a drag on the economy. Basically, NPA is an account which becomes non-viable and non-performing in terms of the guidelines given by RBI. As stated in the object statement of object and reasons, NPA arises on account of mismatch between asset and liability. Bank's asset and bank's liability, my lord, which is owed to its depositors. The interest which I earn on this, my lord, will be used to service the interest which the depositor earns on the money which I am holding as trustee. If this account had been a fixed deposit account, then, my lord, the case would have been different. Then, my lord, I am holding it in trust. There could have been an order of attachment of such a bank account. The NPA, thereafter, my lord, the next line, the NPA account is an asset in the hands of the bank or financial institution. It represents an amount receivable and realizable by the bank. It represents my amount. I am entitled to get it. And that is, my lord, that is public money sought to be taken away from me on the basis of an award. My lord, if it could have been this, I repeat, my lord, your lordship will kindly pardon me for repeating, my lord. If this had been, my lord, the money of the award debtor, definitely. It is not the award debtor's money in my hand. Therefore, NPA Act was primarily enacted to reduce the non-performing assets. And, my lord, I'm not troubling your lordship with
Hmm.
that. Thereafter, my lord, your lordship will kindly take, my lord, this parent judgment of Madras High Court, my lord, which has been relied on by our honorable court also, where, my lord, it has been held that cash credit accounts cannot be attached. Lord, this is 70 LW 1016. Yeah, madam, what's this? Lord, kindly take, my lord, page 1018.
Yes.
1018, my lord. There are something, my lord, in italics. Your lordship will skip that. Provisions are quoted. Thereafter, my lord, it will be seen.
Hmm.
It will be seen that this provision is analogous to an attachment of a debt.
Hmm.
Or what is commonly termed as a garnishee summons. The classes of persons to whom such notice could be served are two. Any person from whom money is due or may become due to the assessee, and any person who holds or may subsequently hold money for on account of the assessee. The question which arises for consideration in the present case is as to whether a bank which has afforded a overdraft facility, Lord, overdraft and cash credit are almost the same, to its customer, holds the amount specified as that up to which the customer may draw as either a debtor of the customer or holds that money on behalf or on account of the customer. This is the question. I shall now proceed to consider whether the bank in the present case stands in either of the two situations mentioned above. The money is standing to the credit of a judgment debtor in the current account of his bank is attachable is beyond dispute. This has been so held on the basis that the bank would be a debtor and could therefore be garnished. Because current account is not a loan account. In current account, bank does not pay interest. In cash credit account, my lord, it is a loan account. Here also bank does not pay interest. But my lord, there is a difference. The difference is in current account, the account holder also does not pay interest. But in cash credit account, the account holder pays interest to the bank because it is a loan. This has been so held, I'm sorry, my lord,
Yes.
that money is standing to the credit of a judgment debtor in the current account of his in a bank is attachable is beyond dispute. This has been so held on the basis that a bank would be a debtor and could therefore be garnished. Similarly, if the money of a customer is in a deposit account, it would also be a case where the bank will be in the position of a debtor or as one who held money on behalf of the customer. It is unnecessary for the present case to complicate it by a consideration of the question which has been the subject of some debate as to the essentiality of a notice of demand before a sum due from a bank to a customer could be treated as a garnishable debt. The sounder and more generally accepted view on this point is that expressed in Jackinson versus Swiss Bank Corporation that a garnishee order itself constitutes sufficient notice to turn a bank into a debtor. That question apart, there must be a debt to be attached. Unless the bank were a debtor, there could be no attachment. And an unutilized overdraft account does not render the bank a debtor. No, my lord, here it is a utilized account. All the more, my lord, I am a creditor. If it is unutilized, I am not a creditor, but I am not a debtor also. Because I have given loan, he has not withdrawn money in terms of this. He has withdrawn money, overdrawn it. There is a debit balance. I am entitled to receive money. He cannot get a walkover. and an unutilized overdraft account does not render the bank a debtor in any sense. And therefore, the bank is not a person from whom money is due to the customer. Nor does the bank in such a case fall within the expression person from whom money may become due. Money may become due. No. From me to the award debtor, money will not become due. Money is due to me from the award debtor. This refers to a case where there is a debitum in presenti solvendum in futuro. That is, where by reason of an antecedent contract between the garnishee and the judgment debtor, a debt automatically emerges. Where the maturing into a presently payable debt is not by reason of external compulsion, but due to pre-existing facts which of their own motion bring a debt into existence at a predetermined point of time. The proposition that a garnishee order does not accelerate the time for payment and it does not alter any of the terms of the contract between the garnishee and the judgment debtor relative to the accrual of a debt are too well established to need discussion. Mr. Ramarao Sahib, learned counsel for the department, did not contend that the margin between what the assessee had drawn and the limit of the overdraft was a debt, either due at the date of attachment or which could have been due in the manner I have stated above. He rather rested his case on attempted to bring the present instance into the second limb of holds or may hold money for on an account of the assessee. The argument under this head was somewhat on these lines. Immediately the customer drew a check on his overdraft account. Lord, he is withdrawing money. Therefore, my lord, the argument is proceeding on that basis. He is withdrawing money, so that money becomes attachable, which the bank had by reason of the arrangement with the customer to honor. The money which it thus decides to pay to its customer becomes at once the customer's money, which between the time when the bank makes up its mind to pay and the time of the actual payment it holds on the customer's account. I must confess that this approach is too metaphysical for me to comprehend. Just by way of illustration, I will take the case of an ordinary lender to whom a judgment debtor applies for a loan. The theory would, if applied to such an instance, result in some such position. Immediately the lender makes up his mind to lend and agrees to do so. That is, the lender holds the sum for on an account of the would-be borrower and, so to speak, becomes the debtor of the borrower. And that when the money is actually paid, the debt is discharged. But it would be seen that if the payment of the loan were thus a repayment of the borrower's money held by the lender, a loan would not result in any debt in favor of the lender which the borrower has to repay. I do not think it is worthwhile pursuing this theory any further. In my judgment, when a bank lends money, an overdraft, and the customer is on overdraft and the customer is always in debit, there is no stage at which the bank is a debtor to its customer, nor at any point of time at which it holds any money of his on his account. Section 46(5)(a) of the Act cannot on any construction be intended as a credit freeze, which this feature superadded. That if there was any thawing, the resultant credit release became immediately payable to the department. Of course, if at any stage the account of the customer is in credit, such section 46 would come into play and the sum so standing to the credit of the assessee might be directed to be paid over. The present is not such a case, and this undoubted right of the department is not what is now sought to be asserted. What the impugned order of the income tax officer directs is virtually that the bank should pay over to the department the difference between the limit of the overdraft allowed to the petitioner and the amount drawn by him up to the date of the notice. This, in my judgment, is not within the scope of the provision, and the order understood in the light of the letter dated such and such is consequently beyond the jurisdiction of the respondent. Notice is accordingly set. Therefore, my lord, in my very respectful submission for an order of attachment to do good, my lord, there should be money in the hands of the bank, held by the bank in trust for the award debtor. It should be award debtor's money. My lord, this judgment
Hmm.
has been relied on by our Honorable Court in 2013 SCC Online Calcutta 19941.
Yes.
Sir, I'll give the copy. हाँ इसमें भी relied. Now, my lord, your lordship will kindly take, my lord, the no, this is Jugal Kishore Das, my lord.
Hmm.
Your lordship will kindly turn over the page. My lord, the paragraphs are not numbered. My
Hmm.
lord, the second unnumbered paragraph from the top. Amidst. Amidst.
Yes, yes.
Amidst pendency of the appeal, the authority, in absence of an order of stay, has initiated the recovery proceeding and has proceeded to pass an order of attachment of the cash credit account. It has been brought to the notice of this court that the petitioner proposed to pay the amounts so assessed by the assessing officer in installments without prejudice to his rights under the statutory appeal and paid the first installment in July 2013. The petitioner did not pay thereafter any installment. The authorities have proceeded to pass an order of attachment of the cash credit account, which according to the petitioner should not have been passed when the petitioner has shown the intention to liquidate and or pay off the amount. The Madras High Court, in case of K.M. Adam, my lord, the one which I cited, held that the provisions contained in section 226(3) of the said act are in the nature of garnishee proceedings and can be invoked against two classes of person. Firstly, a person from whom the money is due or may become due to the assessee, and secondly, the person who holds or subsequently holds money for or on account of the assessee. What can be deciphered from the aforesaid report that unless there exists a relationship of debtor and creditor, the order of the attachment by an authority under the provisions contained under section 226(3) of the act cannot be passed. In the said report, the authority passed an order of attachment of an overdraft account, and in the backdraft of the aforesaid perspective, it is held that question apart, there must be a debt to be attached. Unless the bank were a debtor, there could be no attachment, and an unutilized overdraft account does not render the bank a debtor in any sense, and therefore the bank is not a person from whom money is due to the customer. Nor does the bank in such a case fall within the expression person from whom any money may become due. The court further held that mere providing a facility of an overdraft, it cannot be said that the bank is a debtor to its customer or holds the money for account of its customer in these words. I do not think it is worthwhile pursuing this theory any further. In my judgment, when a bank lends money on overdraft and the customer is always in debit, there is no stage at which the bank is a debtor to the customer, nor any point of time at which it holds money on his account. Section 46(5)(a) of the Act cannot on any construction be intended as a credit freeze with this feature superadded, that if there was any thawing, the resultant credit released became immediately payable to the department. The cash credit limit is a facility provided by the bank to its customers to use and utilize the money. And if such facility is availed of, it would attract interest to be charged for the same to be so utilized. In view of the above, this court does not find, Lord, if Lord interest to be charged, we can charge interest. Lord, your Lordship will see, my Lord, kindly relate it, Lord, to the order dated 28th of February 2020. All other charges, my Lord, the bank will be entitled to realize. My Lord, is there any appropriation or not, your Lordship? Lord, your Lordship's best judgment, my Lord, will deal with this. My Lord, whether still, my Lord, the amount is in trust, my Lord, when I am entitled, my Lord, to debit interests. My Lord, the next judgment, my Lord, is This is Milord 2010, volume 7, Maharashtra Law Journal, page 41. Kindly take note paragraph 8.
Yes.
We have disposed of the writ petition number such and such by holding that the MIDC area is within the municipal limits of the NMMC, and consequently having regard to the provisions of the Act, the NMMC has power and competence to levy and recover taxes, which obviously includes the cess as well. In the present case, undisputedly, NMMC has attached the cash credit account, which in other words is an overdraft facility. The unutilized overdraft account does not render the banker the debtor in any sense, and the banker is therefore not a person from whom money is due to a customer. Nor is the banker in such a case a person from whom money may become due. Where the banker lends money on an overdraft and the customer is always in debit, there is no stage at which the banker is debtor to the customer, nor at any point of time at which he holds in any money of the customer or the later's account. We respectfully agree with the view expressed by the learned single judge of Madras High Court in Adams case, followed by the learned single judge of Karnataka High Court in Karnataka Bank's case. We have therefore no authority but to set aside the other. Lord, these are cases, Lord, which stood on a better footing, where it says that unutilized overdraft. My lord, it has been utilized to such an extent that I am overdrawn. My lord, it's debit balance.
Yes.
Now, my lord, the next judgment is Lord 1992, volume 2 SCC 330. My lord, this was a case, my lord, where fixed deposit, my lord, fixed deposit account was attached. Now, the bank said that this bank did not obey the attachment. Bank raised an objection, Lord, as we have raised. My lord, the High Court dismissed this. Bank said that the person whose account, fixed deposit account, has been attached, that person owes money to me. Therefore, I have a lien on the fixed deposit. You cannot attach it. Don't do it. The objection was overruled. Bank was directed to pay. Bank moved, Lord, in Supreme Court. Lord, the Honorable Supreme Court in such circumstances, Lord, it makes interesting reading, Lord. Kindly have a look at paragraph 15. Paragraph 15.
Yes, yes.
Now the next question is whether the FDRs, Lord, this is, your Lordship will kindly bear in mind, much better footing. It's not a loan. Bank is holding in trust, fixed deposit account, Lord, which bank is, my Lord, in this case, a debtor, my Lord, if FDRs are there. Now the next question is whether the FDRs, which are with the bank and on which the bank claims a general lien, can be attached. So far as the attachment is concerned, the banker's lien cannot by itself be a bar for such attachment. In para 89 of volume 3 of Holsbury Laws of England, 4th edition, the law is stated as under. Attachment of money on deposit account. Your Lordship will mark this. Deposit account. For the purpose of satisfying a High Court or Country Court judgment for the payment of money, a sum standing to a person's credit in a deposit account in a bank is deemed to be a sum due or accruing due to that person and to be attachable accordingly. Notwithstanding that any condition applying to the account requiring that before withdrawal notice be given or personal application be made or a deposit book or a receipt of for money deposited be produced has not been satisfied. Notice and all, my lord, are not required. If there is some due, my lord, that can be attached. Bank says lien. Now, my lord, Supreme Court said mere lien will not do. Then what? In what condition lien will do? My lord, kindly read further. From this, it follows that if a deposit is payable at a future date or after the lapse of a specified time, it is still liable to attach. What is attached? Important. What is attached is the money in the deposit account. The banker, as a garnishee, when an attachment notice is served, has to appear before the court and obtain suitable directions for safeguarding its interest. This also becomes clear from a perusal of Order 21, Rule 46A of the Code of Civil Procedure. The court in such a situation has to take into account the banker's lien. Take into account the banker's lien over the securities or deposits regarding which garnishee notice is issued. My lord, this in my very respectful submission, the court has done, my lord, by passing the order dated 28 February 2020. My lien has been taken note of. I am allowed to debit. Now, my lord, we have already held that the appellant bank has a general lien over those two FDRs. The High Court, having held that the two FDRs can be attached, gave a further direction dismissing the objection of the bank that the bank should deposit an amount of rupees 35,000. As rightly contended by the learned counsel for the appellant bank, the bank in the instant case has the liberty to add just from the proceeds of the two FDRs towards the dues of the bank, and if there is any balance left, that will be the only amount which will belong to the depositor, namely the judgment debtor, and in that case only such amount, if any, can be attached in the discharge of a decree. My lord, it's debit balance. In our case, there is no amount standing as balance due. Cash balance is not there, credit balance is not there, debit balance. My lord, even in cases of fixed deposits, our lien, my lord, if we come and make it, my lord, bring it to the notice of the Honorable Court that, my lord, this is the situation, it is a loan account. My lord, at what pains should the bank go? My lord, this is public money. Why should this be, under what right, my lord, under what law, my lord, I ask this question to myself. Can this money be paid to a private individual, my lord, at the cost of the bank and at the cost of the public? If it was his money, yes. It's not his. I'll give this. I downloaded this year, Supreme Court website. This year. I'll give you. Lord, this is an interesting judgment, Lord. Small judgment, but Lord, whole judgment of the Honorable Supreme Court. Yes. My lord, the facts, your lordship will see, my lord, they are important, my lord. This is an appeal on a certificate granted by the Assam High Court and arises in the following circumstances. The appellant had obtained a money decree against Thakur Prasad Jaiswal and others in 1947. As the decree remained unsatisfied, it was transferred from Calcutta to Guwahati for execution. On May 2, 1953, an application was made for execution in the court at Guwahati by attachment under Order 21, Rule 46 of the Code of Civil Procedure of certain movable property of the judgment debtors, which was said to be in possession of the Subdivisional Officer, Military Engineering Services, Pandu. Consequently, an order was issued under Order 21, Rule 46, prohibiting the Subdivisional Officer from parting with the property of the judgment debtors. It may be mentioned that the subdivisional officer is subordinate to the garrison engineer Shillong. Though certain applications were put in on behalf of the subdivisional officer before the court, it was only on February 1, 1954 that the acting garrison engineer Shillong stated before the court that the movable property in question, that is 41 RS joists, had been sold and delivered as far back as on November 22, 1951 to Messrs. Ghunilal Kanhaiyalal of Palashbadi. This objection was considered by the execution court, and it held on September 25, 1964 that this belated statement that the property in question had been sold as far back as on November 22, 1951 could not be believed. The execution court therefore dismissed the objection and ordered execution to proceed. Thereafter, orders were issued for the production of the joists, but they were not produced. Thereupon, the appellant applied that the Union of India should be considered to be the principal judgment debtor. My lord, this is somewhat the situation. My lord, the debtor is somebody else. It is my money. It is said that now, since you have reorganized the account, you become the principal debtor. You pay it to me. You do whatever you feel like after you have paid. Whether you recover, from where you recover, I don't know, but you pay it to me. Now, my lord, this is the situation here. Thereupon, the appellant applied that the Union of India should be considered to be the principal judgment debtor and execution should be levied against the Union of India. The Union of India objected to this, and on April 21, 1956, the objection of the Union of India was dismissed, and the execution court held that the Union of India be treated as the principal judgment debtor and be made liable to the extent of the proceeds of the attached joists. Later on the same day, a further legal argument was raised on behalf of the Union of India to the effect that there was no surety bond. The Union of India could not be treated as a principal judgment debtor. This objection was heard, and finally, the court ordered on April 28, 1956 that even though there was no surety bond executed on behalf of the Union of India, it was liable as a surety. Thereupon, the Union of India appealed to the High Court against the order of April 28, 1956. The High Court allowed the appeal and set aside the order of the execution court, holding that no action could be taken against the Union of India under section 145 of the Code of Civil Procedure upon the execution court, upon which the execution court had apparently relied. Thereupon, the appellant asked for and obtained a certificate from the High Court, and that is how the matter has come before us. We are of the opinion that there is no force in this appeal. Order 21, Rule 46 provides that in the case of other movable property not in possession of the judgment debtor, except property deposited in or in the custody of any court, the attachment shall be made by a written order prohibiting the person in possession of the same from giving it over to the judgment debtor. The necessary prohibitory order had been issued by the execution court in this case with respect to 41 joists and had been received by the subdivisional officer. Such a prohibitory order is sufficient for the purpose of attachment, though the property mentioned therein is not actually taken in possession by the court. After attachment has been made in the manner provided for by Rule 46, the next step that the court has to take is to order sale of the property attached. Then comes Order 21, Rule 79, which provides that the property sold is movable property of which actual seizure has been made. It shall be delivered to the purchaser. But where the property sold is movable property in the possession of some person other than the judgment debtor, the delivery thereof to purchaser shall be made by giving notice to the person in possession, prohibiting him from delivering possession of the property to any person except the purchaser. In the present case, there was no actual seizure of the property, but attachment had been made under Order 21, Rule 46. The proper procedure for the court to follow was to sell the property under Order 21, Rule 64, and then pass an order under Order 21, Rule 79 for its delivery. The court, however, went on asking the subdivisional officer to produce the property, and when it was not produced, it proceeded under Section 145 of the Code. We agree with the High Court that Section 145 has no application in the present case. My lord, Section 145 is quoted, where any person has become liable as surety for the performance of any decree or any part thereof, or for the restitution of any property taken in execution of a decree, or for the payment of any money, or for the fulfillment of any condition imposed on any person under an order of any court in any suit or in any proceeding consequent thereon, the decree or order may be executed against him to the extent to which he has rendered himself personally liable in a manner therein provided for the execution of decrees, and such person shall for the purposes of appeal be deemed to be a party within the meaning of Section 47. A bare perusal of Section 145 shows that it applies when a person has become liable as a surety. Now the mere fact that an attachment was made of 41 joists said to be lying with the divisional officer by issue of the prohibitory order under Order 21 Rules 46 does not make the subdivisional officer or the Union of India surety the performance of the decree which was in execution. Lord, we do not become surety by reason of mere attachment of the loan account. There was no surety bond taken from the subdivisional officer. And here, my lord, on the contrary, we have been allowed to debit. So surety bond question does not arise. But even if it was, my lord, it says you do not become a surety. There was no surety bond taken from the subdivisional officer, and the joists were not actually seized by the court and handed over to the subdivisional officer as superdar on the basis of a surety bond. If that had been done, some question may have arisen whether the subdivisional officer did become a surety for the performance of decree or part thereof. But where merely a prohibitory order is issued under Order 21 Rule 46, and an attachment is made in that manner. Now, my lord, your lordship will read the order of 28th of February 2020 in this manner: prohibitory order, my lord, prohibiting the award debtor from withdrawing sums, and only in that manner it should be read. Your lordship will be stretching it far, my lord, if your lordship, my lord, believes, my lord, what the judgment debtor, my lord, is persuading your lordship to believe. In any event, Lord, an order of attachment will not, my lord, grant any charge or title to the, my lord, person in whose favor, my lord, the order of attachment has been passed. It does not give him any right, title, and interest in respect of any property, in respect of which, my lord, the order of attachment is passed. Now, my lord, in this respect, your lordship will take this judgment. This is 1910 SCC Online Cal 60. 1910 SCC Online. Lord, your lordship will take the third page, my lord, because there is no paragraph numbering. Page 3, my lord, your lordship will find at the top in fine print, my lord, page 3 written. No, my lord, your lordship will kindly take the third paragraph from the top. It
Yes.
begins with now. Now, in the first place, it appears clear from the order sheets on pages 100, 101 of the paper book that although the original plaintiff decree holder Ramphul Sahu, whose heirs have now become plaintiffs owing to his death during the pendency of the suit, filed his execution petition with a prayer for sale of the property in dispute without any prayer for fresh attachment, the court considered it necessary to issue a fresh attachment owing apparently to the lapse of 7 years, and the plaintiff decree holder, when he came in on the 23rd December 1904, accepted the decision of the court and himself prayed for a fresh attachment after showing cause for his delay in proceeding with the execution. It can hardly be held, therefore, as the subordinate judge has held, that the attachment of 1897 was still subsisting and continued to subsist after the order of 23rd December 1904. But be that as it may, it seems to us impossible to contend in the face of the ruling of the full bench in Frederick Peacock versus Madan Gopal that the plaintiff acquired any title or charge upon the property by reason of the attachment in question. In that case, all authorities are set out, and among them the dictum of the Judicial Committee in Motilal versus Karabuldin, that attachment only prevents alienation. It does not confer title. Therefore, my lord, this argument that, my lord, money was brought back to secure their claim, my lord, that does not bear from the order, bear reading of the order itself. It doesn't say that this money will be held by the bank to the benefit or to the credit or to the or in trust of the award debtor, my lord. This will be reading words into the order, my lord, which the order itself does not say. And Lord, that was not the scope of attachment law. I have clarified, my Lord. It has been said only that right, title, and interest. Now, my Lord, the next judgment will be this, my Lord, AIR 1973, Calcutta 432 or 1973 SCC. Paragraph 8.
Yes.
The attachment may not necessarily be of the property itself, but of the right, title, and interest of the debtor in the property. Now, my Lord, kindly apply this to the facts of this case. What was the right? What was the title? What was the interest? The only right which he could have had upon, my Lord, the account being in debit balance was to withdraw money. What was the judgment passed? Not to withdraw. Kindly read this. The attachment may not necessarily be of the property itself, but of the right, title, and interest of the debtor in the property at the date of attachment. An attaching creditor can only attach the right, title, and interest of his debtor at the date of attachment. And on principle, his attachment cannot confer upon him any higher right than the judgment debtor had at the date of attachment. Lord, this will be conferring higher right. The judgment, it is not judgment debtor's money. If I am, my Lord, asked to pay, my Lord, as if it is judgment debtor's money, then I am not having loan. If a person having a contract of sale in his favor has such pre-existing right, the attachment could not be binding on him. If the promisee gets a conveyance after the attachment, in pursuance of his contract, he takes a good title in spite of attachment. Even if the property is sold in execution, he can enforce specific performance of his contract against the auction purchaser, as the latter acquires only right, title, and interest of the judgment debtor, which is already burdened with the contract for sale. It is true that the attachment holds good in respect of such right as the vendor had in the property at the time of attachment. That is, the right to receive the whole or part of the price on completion of sale. If therefore there is an unpaid balance of price in the hands of the purchaser, the attaching creditor can hold the purchased property in his possession liable for that amount, because by virtue of the attachment, he gets the benefit of the lien. Therefore, my Lord, there has to be something in the nature of the judgment debtor's property which has to be attached. Somebody else's property cannot be attached. Lord,
Yes.
Lord, my learned friend, Lord, is pressing for this, Lord. I should. So this is 2022 SCC Online Calcutta 4114.
On the same point.
No, my Lord. It's not on the same point. My Lord, this is a case, my Lord, where Lord Mr. Saha has argued, and Lord, I will be adopting his submissions on that score also, my Lord, that the proceedings can no longer be maintained. Lord, once, my Lord, this order of attachment,
Yes.
this order of attachment, my Lord, is in aid of the claim. my lord, upon a plan being, my lord, approved. Lord, my learned senior friend will be arguing that point. Therefore, I will not, my lord, burden. I am answering only the charge which was against the bank. And my lord, I have tried to satisfy your lordship on me in my own way. My lord, this judgment, my lord, says that once, my lord, NCLT has taken charge, my lord, a civil court will
Should
stop
not
its hand.
stay.
Will stop its hand. Lord, your lordship will kindly take, my lord. Paragraph 29. As per section 238 of the IBC,
Hmm.
216 is having overriding effect in any other law for the time being in force. In view of my prima facie findings that this court cannot pass any interim order at this stage, this court is of the view that the matter in issue in the suit can be more appropriately and effectively decided and adjudicated by the NCLT. In the present case, section 430, Lord, we are not concerned with that. But NCLT, my lord, the matter is pending. Plan has been, my lord, approved. Therefore, my lord, all the claims will be governed by the plan only. You cannot have a separate claim. And that argument, my lord, of my learned senior friend, that, my lord, money was brought back for the benefit, my lord, the order, the wordings of the order itself, my lord, do away with that submission. In my very respectful submission, my lord. Once my learned friend, my lord, completes, my lord, I will rejoin, my lord, because I will rejoin in my reply. Because they have used an affidavit in opposition to our affidavit, to which we have used a reply. Lord, if my learned friend, Lord, cites something, my lord, I shall distinguish.
Yes,
Back in 5 minutes.
you will back.
And
Are
we were
sure?
thinking that, yes, and if Mr. Saha can also conclude his, then we can rejoin collectively because his point,
But Mr. Shah is supposed to address the court tomorrow, not today.
oh, Your Lordship, then.
He was seeking an accommodation because he is in need of some instruction from the committee itself.
On the last
Else,
occasion,
I can fix it on the on 7th.
Your Lordship just heard the anecdote that till the time the senior asks for an adjournment, the junior.
No, that is fine.
on the 7th.
Instead of tomorrow, because I have some second apples fixed
No,
tomorrow.
Your Lordship, subject to Your Lordship's convenience. On
Whether it can be fixed on 7th.
7th is a Saturday. Your Lordship.
I'm sorry, 6th. Yes.
6th.
Oh,
On 9th, Your Lordship.
can it be on 9th?
Lord, any day after, my lord, my learned friend, Lord, will be going for a medical, my lord.
Very well. Suggest a date. Suggest a date other than
11th,
Wednesday and Thursday,
11th.
if possible.
Yes, my lord, Wednesdays, my lord, even I would pray, my lord, because, my lord, the Honorable Chief Justice, my lord, takes original side matters in the morning on Wednesdays.
13th.
So, my lord, Wednesdays and
13th is fine.
13th.
Then
is
on
fine.
13th,
13th is fine, Your Lordship. 13th is fine.
should I post it?
Yes.
13 তারিখে করে দাও। Whether in the morning or at 3 as directed by our Chief
In the morning
Justice.
is better. It was 13. Your Lordship we'll not waste your court's time, Your Lordship. We'll just consult and we'll get back to
Come
the.
back with a date.
Yes.
I have no issue, but
Yes.
if possible, try to avoid Wednesday and Thursday.
Yes.
Those 2 days are for second apples.
I'm grateful, my lord, for the patience.
Thank you, thank
Your
you.
Lordship.
And what about that written
Lord,
note on
I'll-
accounts?
I will give your lordship, lord.
It's
I
a-
was waiting for everybody to conclude, and
Okay.
Lord, in the end, I'll give a concise
Till
note.
it's a riddle to me,
Yeah, no, my lord. It's a pleasure, my lord. I'll not.
please. Okay, cool.
Will Your Lordship inform the date to the officer, Your Lordship?
Yes. Just Janin, খালি চেষ্টা করবেন বৃহস্পতিবার আর বুধবার এই দুটো দিনটা বাদ দিয়ে। শুক্রবার নয়, শুক্রবার হতে পারে। হতেই পারে।
बात कर लेते हैं।
Let them decide.
Friday 10:30 एक बार बात कर लेते हैं।
Fine, you decide and let him know. খালি বৃহস্পতি এই দুটো দিন একটু বাদ দিয়ে দাও। ঠিক আছে। Friday অথবা Monday, Tuesday, I don't mind.
Monday, I'll be.
No, I'm just giving some options.
Yes, yes.
You just pick up.
He's
You better consult Mr. Bachawat,
Yeah,
Mr.
he's
Shah,
already-
and
I've
Mr.
got-
Rai suggested
No,
date.
no.
I will be there.
he's a accommodating senior, so I messaged him. He said, "Okay, I'm coming."
Had Mr. Om Narayan Rai, Learned Counsel representing. No, switch over to appellate side. Thank you. Your friends are just behind you. From appellate side, yes. এই আমার ওই জাজমেন্টটা বেরিয়েছে, দেখছি দিয়ে দিয়েছো ওখানে।
Friday.
Friday week, next
তো
Friday.
অভিনয় বলেন অভিনয় বলেন। My lord, lord, whatever date is convenient to your lordship, but what I was hoping for, I don't know, my lord. Oh, Mr. Shah is also
Yeah,
convenient.
he said he'll come back with some.
Very well, my lord.
No, you suggest.
Lord,
I have no issue.
I'll just check the date, Lord. Lord, please give me one moment, Lord. I'm very sorry. Very sorry. 13th, I'm in Ranchi on 12th. Okay.
If I may take my lord's.
While lazing over a cup of coffee, you decide.
My lord,
And
13th.
let the office.
Let it come.
No,
13th.
13th. Sure.
छुट्टी के साइड नहीं खत्म होगा नहीं होगा नहीं but is it possible to get any date? Very well, keep it on 13th, Lord. We will take the chance because Lord, I don't want any
I
further.
have no
Lord,
issue, only
Lord,
request.
I tell you, Lordship, Lord, my only request is whatever submission, Lord, they have to make, Lord, this relay race, Lord, first Mr. Shah, then Mr. Lord, then my learned friend, then again Mr. Shah, Lord, this relay race, let it finish. I'll make my submissions once and for all and finish it. Lord, my learned friend has not given us a learned exposition on the subject, but it must apply to the facts. Lord, give me 5 minutes so I can just leave your Lordship with the thoughts. Give me 5 minutes now and then, Lord, give me 5 minutes. I'll come back on the 13th. Lord, two things here, your Lordship will remember, Lord, on the last day I said there are two separate compartments. One is the NCLT business, one is my learned friend's case. Now, but please understand this, today there is some money lying somewhere in a bank account. For a moment, Lord, let us forget the nature of the account. For Mr. Shah to object, he must first say it is my money. My learned friend says it's his money. In which case, Mr. Shah's client can have no, my lord, claim to this money. It cannot come and disturb these proceedings like it has for the last 2 years. It is no one's case, not that it is their money. But they are the ones who have successfully derailed my trying to get the money. Lord, if my learned friend's contention is to be accepted, it is his money. It is not Mr. Shah's client's money or its predecessor, whatever. If so, Mr. Shah should not be permitted to not say a word now. Like I've said, he has taken conflicting stands at different stages only to delay. That delay has happened. But today it is very clear that, Lord, a plan has been accepted. Under the plan, Lord, he can have no claim at all to this money. Otherwise, he would have said, this is my money. It's not his case. So, Lord, Mr. Shah's client out of the picture. Now, Lord, having got rid of this, let's call it nuisance value, I have no problems if 5 lawyers come. Lord, that's good. It's interesting. But, Lord, really speaking, he was nothing but a nuisance factor. We've gotten rid of it, which leaves only one question before your Lordship. Am I entitled to realize the money which is lying out of an attachment made by court prior to the order of insolvency? This is the core issue which your Lordship has to decide. Now, my learned friend, Lord, he is proceeding on a very dangerous basis, which is not anywhere in his pleadings. He says there is no order of attachment. This is his submission. Please note it. Now, I would invite my learned friend to show his affidavit saying that the order of attachment is gone. On the contrary, I'll show you his affidavit. After these orders are passed, he says, very sorry, I have violated it. Please forgive me. Please don't send me to jail. My employees have done a wrong and I'm taking criminal action against them. I'm taking disciplinary proceedings against them. That is his case. So this order, not this entire line of argument based on the fact that there was no order of attachment, or if it was there, it got varied, modified, it is not to be found. This is
Yes, that
one
is the
part.
precise argument.
So, Lord, if there be no order, Lord, if there is an order of attachment, then this entire line of Lord judgments which he cites are completely irrelevant. I'll show your Lordship that they otherwise favor me, because for them to apply, there has to be a second premises. I'm not going into it now because I need to see those judgments properly. If my gut feeling is right, my learned friend is proceeding on a basis which has no factual foundation. But if the order of attachment remains, these judgments go. Now, 2 more things over here. I'll show your Lordship the effect of what happens when an order of attachment is made. That property, whatever it is, becomes custodia legis. It remains outside the scheme of any other attachment which may take place, whether by a insolvency court or any other court. Number 1. Number 2, I say that, Lord, my learned friend has no claim to the money. But look at the dangerous argument that they've run, contradictory. If Mr. Shah's argument is to be accepted and it's not disputed by my learned friend, what happens upon a resolution plan being accepted? Any creditor loses his right, it gets transferred to the money lying over there in the insolvency body. You go claim it there. So if there's 10 rupees lying there, you may have a claim of 50, but you may get 1 rupee or 2 rupee, but your claim vanishes into the blue according to them. Extinguished, clean slate according to them. Now, why did my learned friend not tell your Lordship that he has gone, if he has a claim against the company, the corporate debtor, if he has a claim, fact is he has gone to the NCLT. He has put in his claim. He is realized as a secured creditor of what amount? Of the money which is outstanding in this account. So he has also not got it fully. His claim or his right to this money is also extinguished if their argument is correct. He can't lay a claim to this money because he has recovered it in the NCLT. This is the position. He is the one who invited it. He is on the committee of creditors. He has realized as a secured creditor. So his claim to this money, Lord, if at all, is gone. If that argument be correct. Now my position is different. My claim will not be gone because I have obtained a pre-order attachment, pre-insolvency attachment, and when I have gone there, I have taken it without prejudice to my rights. My learned friend has not once told your Lordship that he has done it without prejudice.
But the difficulty, sir, what
Yes, sir.
Mr. Rai is
Yes,
propagating, that you cannot attach or court cannot attach anything which is not the property of the.
Correct. Now I need to show your lordship whose property it is. Not whoever's property it was. Whoever's property it was. The fact is, not let's put it this way. Not forget the facts of our case. There is a bank account in relation to which, let us say, Lord, I as a creditor, forget as a banker, I had a claim of 10 rupees. Now, Lord, that person is taken to NCLT, goes into insolvency. My claim to that 10 rupees, let us say if it was lying in the bank account, let's forget the nature of the account, whether it's cash credit, overdraft, fixed deposit, let's forget it. There was, let us say, money lying in an account. When I go to NCLT, Lord, what happens? Whatever is realized from sale of all assets, properties, whatever, I go and lay a claim there. When I lay it, my claim over here, according to the judgments they show, is extinguished. So, Lord, my right over the attachment or the right over that money would otherwise then go to NCLT. This stands released because my claim has merged with what is given in the NCLT. This is the position. Now, if that be the position, I'll assume that this was my learned friend's property. I'll assume for a minute. Whatever is there in these accounts was his money. But where has he realized it from? Not from this account. He has gone and realized it in NCLT. So therefore, now what happens? Can he have a double claim? I go realize it in NCLT and then I also claim this money. Now, we are talking about a situation where there is actually money lying there. We are talking about that. He could not have laid his hands here and there. Can't be double recovery for him.
And where there is no money,
Now, coming to that. Now, whether there is money or not. So, the first limb of my argument is, moment there's an attachment, custodial legacy. Now, second point. And fully covered by a judgment which I've handed over to my learned friend in earlier proceedings. He knows it. Unfortunately, he did not deal with it. Now, what that judgment says, no, my lord. Yes. So, no, I tell your lordship the principle. Now he'll deal with it. Now, Lord, if that principle is right, then these 10 judgments.
Lord, kindly remember on the last occasion,
Lord, I did not learn it. I did not once.
I was about to. Lord, I did not interrupt. Because of this, Lord.
let him have it.
Now, Lord, the principle. I give your lordship the principle.
I have dedicated the whole day for you, so don't worry.
So, Lord, please remember the judgments which he cites. Number one, none of those judgments are cases where money is brought back pursuant to a court order or otherwise. Now, the law is, like in this case, he allowed the money to be withdrawn in violation of court order. He apologizes. He files an affidavit saying, sorry, I'm in contempt. Please don't haul me up. I'm taking action against my officers. He does that. Now, having done that, Lord, what happens next, Lord, is interesting. The money now, Lord, materializes out of somewhere. My learned friend has tried very hard to explain it. Unfortunately, all this, Lord, which he gives your lordship, he didn't tell the court at that stage. These documents are not on record. That he reorganized, got money by magic from here or there. I don't care. Lord, is it my lookout where the money has come from? I have obtained an order of attachment. Why does the court grant an order of attachment? To ensure that my decretal due is paid. So the money comes back magically. It is now being held for my benefit. He doesn't say, look, this is not Shrey's money. This is some invisible accounting entry I've done. Doesn't tell the court all that. I'll show your lordship his affidavits. So, Lord, what do I think? Yes, now there is real money lying here. After all, Lord, not a small amount of money. How much came back in? 500 crores, Lord. Now, my learned friend says it's a book entry. I take a pencil and I write something. Money is magically in. If that was the position, then there was no
Now
contempt.
the claim is restricted to 50 crores.
Yes. So now, Lord, 500 crores comes in. Now, the law, and this is the judgment which I'll show your lordship. What it says is, once it comes in, it is held in trust without lien, without any claim by the blank. It is held for a particular purpose, which is free of all specific and general lien. It is held for the benefit of the person for whom it has been brought back. So, my lord, now this money becomes exclusively set apart for me. But the moment he consented to it, allowed it to be brought back without objection, it is no longer his money. And as far as I am concerned, and the court was concerned, it was money brought back in by SRE. If he chose to give a further loan to SRE to put this back in, that's his lookout. He took the risk because he knew he was going to jail. His managing director was going to jail. He took the risk. He provides a loan to SRE to bring this money back in. That's his lookout. You go recover it. If you've given him a loan to bring the money in, I don't know about it. The direction was bring the money back in. The money came in. What source? What was the internal arrangement? I don't know. I don't care. You can't fool the court like this. Did he tell the court that this is what I've done? Did he disclose it? And after that, he refused to give us accounts. And I had to come to court again. So, Lord, the law is once brought back in, he loses all right to it. It is exclusively then earmarked for me. This is not invisible money like my learned friend says. Simply money, I've taken a book of account, one day I make a debit, next day I make a credit. And Lord, please see the argument he has made. Lord, I tell your Lordship, the argument he makes should ensure that, Lord, all his officers go to jail. What did he say? Lord, please remember, this is a company who, Lord, a creditor has not taken to NCLT. The Reserve Bank has taken them. Administrators appointed. Why? They are guilty of large-scale fraud. Now, from my learned friend's submission, Lord, what is appearing? That they were party to it. He said that he did not want that company to become NPA. So when required, he has made debit entries to prevent it from becoming one account from becoming NPA. He shoves it into this account. Then when it doesn't suit him, because I'm going to catch it, he puts it back into another account. By this process, my lord, he has prevented the company from being declared as an NPA for 2 years. And ultimately, the RBI had to haul him up. But is he a party to all this? For my learned friend to make all these submissions, well, I'm stunned. I'm stunned.
I'll remove this stunning.
Lord,
Once I-
I'm stunned. So, Lord, I'll come make my submissions. I'll consider his judgments and, Lord, I'll deal with it and I'll show your Lordship my judgments. I'll show your Lordship. Now, Lord, this is the one judgment which covers this entire situation. None of my learned friends' judgments do. And it's based on a Supreme Court judgment which says the same thing. I'll show your Lordship that. My learned friend has been given copies of these. We have cited it elsewhere. No attempt to take care of this.
No, why, my lord? It has to be cited before your lordship, my lord. Then only I will deal with it. I will not take out a judgment, my lord,
Very well.
which he has cited.
All
my
you
lord.
need to do is to solve the riddle of accounting.
Yes, my lord, I'll
That
do
part you
and
just
lord,
help
please
me out.
Allow me to rejoin on my reply on
Lord,
this.
just one point, Lord, again, Lord, it's something that I invite my learned friend to, Lord, inform your Lordship. Lord, has he made all these claims before the NCLT in recovering his claims?
Well, my answer
Is the amount in this account? He was arguing.
May I have your lordship, please? Since Mr. Bachawat will not conclude today, he says, then I'll come back whenever your lordship wants.
Very good.
No,
Thank
told
you.
you on the 13th track also. 13th. Friday the 13th. Friday the 13th. Well, my learned friend is in a real rush to go away.
Unfortunately, my lordship.
I will wait for him to go and finish the matter expert. Now, Lord, this entire thing is what? Not about that money lying in this account. Now, has he got back this amount of money from the NCLT? Has he made it, claimed it? He must have. He has gone in with a superior claim than mine. He has gone in as a secured creditor, which, as Mr. Shah has not informed your Lordship, gets a much higher percentage of its claims. So if he's recovered it, what is this fight about? My learned friend can't get money from there and from here. But this is more or less the long and short of it. Factually, your Lordship has to only see, number one, Mr. Shah's
No,
claim.
what would be the fate of this loan account? I mean, cash credit and then your overdraft. What would be the fate of this account pursuant to this proceeding before NCLT?
But it'll depend. It'll depend on what my learned friend has to tell your Lordship that look, I claim. Let us say, my lord, he has a claim. He says of 300 crores or whatever in this account against Shrey. Let's say, I don't know what is the amount. Now, my lord, if these 300 crores he has realized from NCLT, then he can't have any claim at all. If he has not, then going by Mr. Shah's clean slate principle, that has got wiped out. So either which way he can't have a claim here. He can't. But in law, I tell you, Lordship, there's just this one point of law now left. But what was the effect of the money coming back in? But if I am right in my submission, the money once it came back in, it is exclusively for my benefit, which he could not have touched. But his judgments are, look, if money was lying in an overdraft account, I couldn't have touched it. Answer is, look, all that changed. All that changed. You made that mistake. Money was then brought in for my benefit. Once it's brought for my benefit, it remains for my benefit till I get my pound of flesh.
No, according to Mr. Rai, the
Yes.
account was never replenished by the debtor. I mean,
But how does it matter to me? Like I told your lordship.
so there was no inflow of money. That is what he is indicating.
But he's told the court, yes, money is in float. Court order was bring the money in. Court's order was bring the money in. He has brought it in.
That is what Mr. Rai is
Yes.
submitting.
Very well, I'll show the order. I'll show the but like I said, that's the core area. What is the effect of the money being brought in? If my learned friend is saying he never brought the money in, let him say so. Where does he say? I never brought any money in. Where is this not in affidavit? I never brought any money in.
Lord, where have I
If
said that I have
there
brought
was
money?
inflow, then custodial legis theory will come and it is inescapable.
Bro, where is this story that no money came in? My learned friend is not, like I said, academic arguments are all
No,
fine.
Lord, it's
They must
very
apply to the
explicit
fact.
order that money has to come in. The order
Oh.
says reorganize the two accounts. Lord,
Okay, I'll show the order.
Lord,
I'll
I
show.
will also show
I'll
the
show
order.
the order.
then. Very well.
You, oh, when will you show? What do you mean? I
After
will
you
show.
finish,
No,
after
I
you
thought he's finished showing
No,
whatever
no,
he had to.
Lord,
He's
I will
finished
have
his
to reply
submission.
to what he has
He is
submitted, Lord,
finished.
because I will have to answer on my reply to the affidavit in opposition that is used. He is opposing my prayer of objection today.
Very well, you carry on. You are most welcome.
So let
I
him
am
finish that.
enjoying.
No, I have finished.
I am enjoying reading over this new arena.
Yes, sir. Not so. So are we. So are we. But not. No, no doubt not. My learned friend has given us a very learned exposition
I have learned
of the
it
law
from
on this
Mr.
area,
Bachawat
of
only.
the law in this area. Of course, it must apply to the facts. That's all. Not. It's good not to know no law. It's very good to look. No, not. But then I've got slapped by my senior many a time by when he told me, look, you must know how to apply it to the facts of the case. So, not,
Lord, I'll be love to be slapped by my learned senior friend
Lord,
here, my Lord.
Lord,
But I
he's
think I will
authority.
not get,
He's
my Lord, I
authority
will
on
not give
this.
him this
Not
opportunity, my
he's
Lord.
authority on this. He's very good at his. Not
No, no.
yeah, no doubt about it. But it must apply, not in the facts.
So on 13th.
13th.
Heard Mr. Rai, then Mr. Bachawat, learned senior counsel for the Where is Mr. Bishwas?
My lord, I am for the appellant.
That I know, but I need your friend before me.
My lord, I am not sure whether
We're not sure. Very well. No. হ্যাঁ বাকিটা একটা 4 PM আছে ও সবটাই 4 PM. So I have no business now till 4. Fine. তাহলে একটা কাজ করুন, ওই আমি ডিকটেশন গুলো দিয়ে দিই। পিএ কি কেউ এসছে? এখনো আসেনি? তা একজনের তো আসার কথা ছিল। টু টেক ডিকটেশন যোগাযোগ কর। পিএ কারোর আসার কথা, সোমনাথের মার অ্যাডমিশন অপারেশন, ডিকটেশনটা দিয়ে দেবো তাহলে। সৌরভ বাবু ছাড়া আর কে এসছে? ওদের কাউকে ডেকে নিলে হবে। Very well. এইগুলো একটু ভেতরে পাঠান। একটা জায়গায় ডেট চেঞ্জ হয়েছে জাজমেন্টে, ঠিক আছে? Item 2. What is the number? SA 135, Prakash Chand by the, yes, your appeal is accepted and you are the appellant. Your appeal, yes, your appeal is accepted. But on a different score. You know, pursuant to transfer of interest, I found the argument advanced by your senior Mr. Ghosh becomes more academic. In a sense, now the landlord is a real title holder by purchase. So concurrently, its concept, it will be mere academic. I didn't deal with that issue, but what I decided that, look, in order to have the decree on the ground of reasonable requirement, you need to show that you do not have reasonably suitable accommodation elsewhere. So the ground for which X was granted the decree, the same is not applicable to Y. On that score, it has gone. That's it. Under section 103, perhaps I had to deal with. Not 103. I formulated a question, substantial question on the last occasion, and I decided on that. In any case, you are now saved. I don't know for the time. But this young man, young friend of yours is really good. I'm quite impressed. Dipta Banerjee. Good. If he can keep it up, he will become a good lawyer one day. So I have no work today till 4. Thank you. রঞ্জিত এর পিএ দেখুন ডিকটেশন গুলো দিয়ে দিই যখন সময় পেয়েছি। হ্যাঁ, এক্ষুনি কথা বলুন। থ্যাংক ইউ।
Mr. Ganguly is coming.
Where is Mr. Ganguly?
Yes, he is coming. He is on his way.
Mr. Gupta is in another courtroom, Lordship. He is also coming, Your Lordship. I'm filing my written notes of argument, Your
What's
Lordship.
the point? I could have,
The matter
I
is
was
over,
in
he
the
will
midst
just
of
come, Your Lordship.
dictating judgment.
Just he is coming. He is on his way.
Lordship, I also file my written notes of argument, Your Lordship.
Written notes of argument. Two proceedings on the identical fact.
Yes.
Very well.
Only one thing, one matter, it relates to the non-deposit of provident fund amount. Part
And other one is for
and other
recovery of
two are,
interest.
the less charge, the lesser amount.
Non-recovery of interest,
lesser interest has
statutory
been
interest.
charged.
Yes, I remember. But why these people are there? They are not. Who are they, Mr. Sen? Yes,
Yes, my lord. Your lordship be kind to allow me to mention in an extreme urgent condition, my lord. Our matter is a simple case of partition and administration. It is lying pending since 1989 in spite of order of 6 October 2020 when in a partition suit, court has passed an order for declaration of shares by next court. Still, till date, we are suffering from extraordinary detrimental effects.
are you appearing in person?
We all are appearing in person. Will that be a problem for your lordship? Yes, today only I came to know that it has been assigned before your
It has
lordship.
been assigned.
Yes, and
But ma'am, this is not the right time to mention.
I know.
Please do
That's
bear
why
with
I
me.
was waiting for kind
Yes.
consideration of your lordship. And if your lordship kindly consider, we would be ready to appear tomorrow at 3 p.m. It is an extreme sensitive issue of 10
No,
owners,
whatever it
including
is.
8 lady owners are at dire state, my lord. It is a severe kind of property theft. Severe kind of property theft, my
So
lord.
that's fine. I will take up
And
your
it
matter.
comes with Trespassers Act and removal of trespassers already done through an order of court. Still, it is pending, my lord. And I have to help all these 10 owners, 8
Very
lady
well.
owners.
How many persons are there appearing?
10 owners are appearing person, 2 owners are extremely difficult conditions.
10 co-owners.
10 co-owners.
And you are all agreeable to partition.
Yes, agreeable to petition and
Then what's the issue? Why it is pending?
that is the unknown reason. We don't know why it is still pending.
No, if it is pending, then if you are agreeable, better you should.
Everybody agreeable.
So better you should take it to the mediation center and get it done. Why you
Mediation
are-
will not happen because it has been a property theft, attempt of property theft in the name of Hindu idol. My lord, it is really striking.
So
picture.
matter is not that simple as you are projecting.
It is exactly simple. If your lordship has some problems, your lordship can freely release it. We can gladly accept it, but it is extremely urgent, my lord. We
No,
can't go there.
I appreciate the urgency, but when you are not at issue, the way you are submitting that all the co-owners are ready to
Yes,
accept the partition,
yes, yes.
then parties are not at issue. Then
Court
it
did
should be a
not
close
favor
case.
us. Court did not favor us in proper prosecution. I don't know why. No, it is not the Bhaktar.
Secular properties.
Secular property.
And all the 10 co-owners are ready to,
Ready, even if it is Devattar.
then who is standing on the way?
Yes, those plaintiff number 2, whose father has lost this partition suit when his father found that his one of my uncle and his son were packed together to swindle this entire property of 24 katas in posh area of Bagbazar in the name of Hindu idol, my lord. So there is apprehension in our minds also. Yes, my lord, in 1905,
Right, very well.
1905, there was no right to the property of an widow. Co-personers have an idea, right to ancestral property. So many courts, so many advocates, nobody knows this idea. We are common people. We have got this thing. The very first day after 1989, court should have found out by searching through officers of this court. So many officers are recruited every year. There are so many departments in court. I feel really embarrassed, my lord. I can go dead. I know all political encroachment in our building, my lord, in our position. They have destructed our
So
position.
there are issues. Very well.
My
This
lord,
is not the
kindly
right time,
give us-
madam.
Give us time at 3 p.m.
Yes,
tomorrow.
you come tomorrow. I will try to accommodate. I will try to take up your matter, but this is not the time.
I know, ma'am.
Yes.
I know, my lord, I know everything.
Yes,
I
you
was just standing over there,
fine.
only standing over there,
Since
not
it-
to disturb your lordship.
No, it's fine. Thank you.
Tomorrow at 3 p.m., my lord, only IA 42 explains everything, everything. I have given the sketch of the property and it has been served on
No, you come in the morning.
in the morning.
In the morning, it is to be enlisted. It will not be in my list tomorrow.
Then-
It is to be enlisted, then we will decide.
So what time I will come at 10:30?
No, normally we take this mentioning matter at 10:30 itself.
10:30. Yes, my lord, I will.
It
come.
will be included in the list, then the date for your hearing would be fixed. Please appreciate that, ma'am.
It is extremely urgent and regular hearing will continue
Maybe.
tomorrow at 10:30.
Yes.
Grateful, my lord.
Yes, Mr. Ganguly.
May I take back the notes of argument for a moment?
Why not? It's your property after all.
Instead of 2001, it has become 2021.
Okay.
That- Whether I've had the occasion to hear my defense. Primarily, what I could find was that the main arguments were with regard to 468 of the CRP.
Yes.
And in connection therewith, my learned friend has relied upon 4 judgments. Now, if your lordship kindly sees. First one, 1984, SEC 20.
Then
Only before that, may I beseech your lordship to kindly take up the respective application.
দেখি ফাইলটা দুটো এখানে আছে এসি চলছে না নাকি
My lord, I came looking back with arguments.
No.
That's why I'm.
Sierra 2974.
My,
Yes.
if your lordship kindly see, because one of the contentions is that this is a continuing of it. Now, if your lordship kindly see page 16.
Yes.
Kindly see the period at page 16.
Yes.
It is from 1798 to 31. And the interest chargeable on refundable loan is this. Interest charged on refundable loan by the Board of Trustees is 5%. Now kindly see page 12.
Yes. Page 12.
4 and then the handwritten part. 297. Field. Page 12.
Annexure P1.
It's the complaint. Yes, annexure P1.
Yes.
Starts from 11
Yes.
and 12.
Yes.
The handwritten portion towards the middle. Failed to charge interest for the period from 10/7/98 to 31/3/1999. So a determinate period. Now, your lordship, in the next other ones, your lordship will find from 2975.
Aditya, 2975.
I'll show what the others are all similar. The other three are all similar. Fail to sorry, page, it would be second page of the complaint.
Yes.
I think whether
Fail to invest.
yes, fail to invest provident fund monies within the stipulated time for the month of November 98 to January 95. So again, the offenses for a definite. It is
Yes.
not indefinite. So what has been my learned friend's submission is that these are continuing offenses. From his petition of complaint, it is apparent that all the offenses are determined by a time period,
Yes.
and therefore they expire at that point of time. The second issue is, my lord, the period of 1 year was calculated from the date of the grant of the sanction. So it was not from the date of the completion of the offense till the sanction being prayed for, sanction being granted. We have calculated after the sanction. And even then they have failed to pay, file it within a period of 1 year. So it cannot be their case that the offense was continuing when we also obtained the sanction. Their petition of complaint also reflects that the offenses are determined by a time period. So the contention raised by my learned friend that these are continuing offenses has nothing, is not applicable here. Well, that's why if your lordship kindly sees paragraph 10.
Yes. Paragraph 10 of the petition of complaint.
My lord.
Yes.
Well, portion where, well, which is at page 227 and which is extracted.
In the
Well, the judgment in 1984-4. Well, that is ours. My learned friend had relied upon Bhagirath Kanoria, 1984-4, SCC, page 222. An experience.
yes, Bhagirath Kanodia.
Bhagirath Kanoria, page 227.
227. Yes.
Well, towards the middle.
While discussing the question of
Yes, I'm deeply obliged. Make the following observation. A continuing offense is one which is susceptible of continuance and is distinguishable from the one which is committed once and for all. It is one of these offenses which arises out of failure to obey or comply with the rule or its and which involve a penalty, the liability for which continues until the rule is obeyed or complied with. On every occasion that such disobedience or non-compliance occurs, and there is an offense committed. In our case, that is not so according to them. According to them, I failed to deposit, I failed to get the refundable, on respect of a refundable loan for the period from this to this interest. So when they determine the offense by a time period, well, they cannot thereafter blow hot and cold. Now, with regard to the second judgment, well, the N.K. Jain, if I'm not wrong, is 1991-2.
$1991.
Will it has got it?
Yes, yes,
Will it kindly see page 499?
yes.
The first paragraph. What was decided? What was the issue which fell for decision? The question of general importance that arise in these appeals is whether criminal proceedings can be instituted under section 14 of the Employees Provident Fund and against an establishment exempted under section 17 of the Act for the contravention of the provisions of section 6 of the Act. Now, who is the establishment? The appellants who are common in each of these three appeals were connected with the management of Sri Shubh Lakshmi Mills Limited, hereinafter referred to as the company, an establishment governed by the Act. By a notification dated this in excess, the central government in exercise of its powers granted exemption to the said company subject to the conditions specified in this. As a result of the said exemption, the provisions did not apply, and the management made contributions of provident fund to the said trust. Now the issue was whether the company would be made an accused. Here the company is not an accused.
Yes, that is there.
So ultimately, this judgment has no relevance. And paragraph 21 kindly see the last paragraph at page 523.
Yes,
From the above discussion, it emerges that at least sections 14(1)(a) and 14(2)(a) are attracted to the facts in the present case, and therefore it cannot be said. This is in respect of an officer of a company which has been exempted under 17, for which a provident fund trust organization has been started. So this only says that 14(1)(a) may be applicable to the officers of that company. Here they have not prosecuted the company or its officers. So I don't know, with great respect I submit that this judgment at least has no application to the facts of this present case. Now kindly takes up the next judgment. Anjuman Tea Company Limited, reported in 2008, Volume 1, CHN 1061, Calcutta.
yes,
Will you kindly see paragraph 2? First of all, this is a case under section 406, 409. And the issue which fell for decision by this honorable court is if there is a subsequent payment, whether the case under section 406 or 409 will go up. I did not submit with your lordship that a judgment decides the issues that are there in that judgment. It is not a Euclid's theorem that it will be applicable to everything. And paragraph 5, my learned friend refers to, is at page 1063. It's a submission. This is a submission. And kindly see what the this honorable court says. Kindly see paragraph 9. Very rightly, it can only be a mitigating factor in respect of the sentencing. Anything to do with the facts of these proceedings. This is not even the case under the Provident Funds Act.
reminiscence of the past. Mr. Gupta assisted the court in this matter.
Well, The next judgment is reported in 1992, supplementary Supreme Court cases 10. Well, in this judgment also the Honorable High Court, while sitting in the single bench, had exercised its powers under Section 633 of the Companies Act. And exempted the delinquent establishment from the effects of the Provident Fund Act. The Honorable Supreme Court held that Section 633 of the Companies Act 1956 was only restricted to offences, violations under the Companies Act and does not relate to other acts. This is what has been held by the Honorable Supreme Court. How does it apply to our case? Kindly see. Well, it kindly takes it up from paragraph 2 at page 13.
It is enough if we refer to the facts in Civil Appeal number 3012 of 1990. The short facts are as follows. Eastern Manufacturing Company Limited is the owner of a jute mill. The appellants were appointed directors between this and this. There was a lockout in the jute mill on this. By a notification dated this, the government of West Bengal declared the said jute mill as a relief undertaking under the provision of West Bengal Relief Undertaking Special Provisions Act 1972. However, on 24th of November 1983, the lockout was lifted. Thereafter, the mill resumed its manufacturing operation between January 16, 1984 and April 8, 1984. There was a strike in the jute industry throughout West Bengal. Between 1985 or March 1985 and August 3rd, 1985, there was lockout due to labor unrest. As a result of all, these companies defaulted in payment of the Provident Fund dues. Then kindly sees. On January 28, 1986, a petition was moved on behalf of the appellants under Section 633 of the Companies Act 1956 for being relieved of liability for delayed as well as non-payment of the Provident Fund dues and other ancillary dues. On August 21st, 1986, a consent order was passed by the learned single judge, allowing the outstanding Provident Fund dues to be paid in monthly installments of rupees 50,000 commencing from April 1986 until the entire liability is paid off. Since the course was accepted by the Provident Fund authorities, it was not considered necessary to serve summons on the register of companies because what was sought to be recovered were the dues under the Provident Fund Act. It was further ordered concerning prayer B that an injunction shall issue restraining the respondents from initiating any criminal proceedings against the appellants or any of them for non-payment or delayed payment of the Provident Fund. Aggrieved by this order, respondent number 1 before us, namely the Regional Provident Fund Commissioner, filed appeal number this. The division bench which heard the matter rendered its impugned judgment on this. The sole point which came up for determination was whether the learned single judge was right in granting relief under Section 633 of the Act in respect of offences committed under the Employees Provident Fund and Miscellaneous Provisions Act. So this was the issue. Then kindly sees paragraph 27. It's a biggish paragraph. It starts from
Perhaps from page 21.
It starts from page 21, but I'll not trouble your lordship to that, except kindly takes it up from page 23.
Yes.
Just before paragraph 28, placitum C. Thus, we are clearly of the view that under 633 of the Act, relief cannot be extended in respect of any liability under any act other than the Act. Other than the Act means the Companies Act. And my learned friend has relied upon 29. This relates to, again, an establishment, does not relate to any exempted authority. And this anyway, your lordship has seen the issue that was there before, which was formulated by the Honorable Supreme Court, and the answer thereof. This is not there. Then therefore kindly sees at page 24, the 1, 2, 3, 4, 5, 6th line from the end of paragraph 29. They will not be entitled to any relief under section 633. The benefit availed under a social, namely this cannot be defeated in this manner. We may also that if the interpretation suggested by the appellant is, it would cover not only the existing law, but all legislations to be enacted in future. Now, therefore, what the Honorable Supreme Court says is that you cannot get an exemption for an offense under any other act other than the Companies Act under section 633 of the Companies Act. Well, at 633 permitted the Honorable High Court from preventing any prosecution to be initiated against a company, and that was usually done on the basis of a show cause notice, which was usually received by the company. They thereafter moved under 633 saying that these are minor violations, we have complied with the same, so kindly excuse us from the possibilities of prosecution. The Honorable, because here it was under using 633, the proceedings under the PF Act was being attempted to be also stopped. The Honorable Supreme, you cannot do that. It will be only confined to the offences under the Companies Act. So with great humility, I again say, this judgment does not in any manner relate to the issues that were raised. They do not relate to, they do not relate to the question with regard to 468. I have already shown to your lordship, by their own complaints, they have limited it for that period. With regard to 14(2)(a), they themselves have introduced it in the complaint. I have not introduced it. They have done it. And with regard to the order taking cognizance, I have already submitted. Well, those have not been answered by my learned friend. So these are my humble submissions.
My lord, kindly take another day, my lord. I give
Reply against reply.
my lord, no, I just received notes of argument today.
So what? We have not added anything beyond that.
My lord,
No, my lord, kindly does not permit
15
this.
minutes, my lord.
My lord, there is no reply against a reply.
How could you? How could you?
That's why, my lord, I have just received notes of argument today, my lord. Give any day for 15 minutes.
Sorry, Mr. Gupta. You can discuss the issue with Mr. Ganguly while lazing over a cup of good coffee. I cannot be a party to that chat, of course. Yes.
I'm leaving to your lordship, my
No,
lord. I have already annexed 4 judgments.
yes, I will.
Which is applicable, my lord. My learned friend, last judgment will showing, my lord. That is
No,
also.
it was only referred to by you.
Yes, my lord. I have annexed all the judgment which I.
I have not submitted on anything other than what my learned friend has submitted.
Mr. Ganguly was only distinguishing the judgments relied upon by Mr. Gupta.
But my lord, notes of argument which has submitted.
I
my
have
lord,
not
have
said
received.
anything beyond what I have said. The 3 issues that were there, 468, 204, 190, and the other is with regard to 14(2)(a). That's all. I have not said anything beyond that.
Leaving to your lordship, my lord. What you I leaving to your lordship, my lord. Whatever design, my lord.
Yes, Mr. Banerjee, what can I do for you? Judgment, very well, yes. Ranjit, ওই জাজমেন্টের মধ্যে what was the number of your appeal?
Say 135 of 2009.
একটু এনে দিতে পারবেন 135 পারবেন?
Very grateful that your lordship gave me the opportunity to argue that matter for so many days.
No, it's your business.
And to take
And,
up so much of your lordship.
It's my duty. What else I could do other than lending my ears to an advocate? That is the only job I can do.
Your lordship was very kind and very.
But yes, you keep up your temperament. I hope you will glitter one day in the High Court. Thank you. Now, I only decided this appeal against you, taking into consideration the subsequent event. My logic is clear that requirement of X cannot be the requirement of Y, and it does not. And rest of the issues are mere academic because there was no lease, so question of concurrent lease and
Yes, I fully accept.
go through it.
Sorry to put your lordship to the trouble the time.
No,
that I
no,
think
it's okay. It's okay. You take the pencil.
I
And-
didn't make any marking. I'll just go through the judgment.
No, no, if you find any error, typographical error or anything like that, just underline that.
I'm good.
Thank you.